We're joined by Shardul Shroff, Chairman of Shardul Amarchand Mangal Das. Mr. Shroff, good afternoon. Thank you very much for joining us. The first change that I can see is the language in 29A. This is the introductory paragraph, and I'm so sorry to make this so legal for our viewers, but this is the only way for me to explain it. The introductory paragraph that goes on to lay which people are ineligible to present a resolution plan, the language of that introductory paragraph now seems to be leaner and cleaner and no longer considers ineligible the promoter of a resolution applicant or those in management or control of a resolution applicant. Would you agree with that? How do you read it? What should the interpretation be?
I think I agree with you, because there was a complex opening sentence of clause 29A which has been significantly simplified, and now in relation to the promoter, they have linked it to an account or plural accounts of the corporate debtor under management or control, or a person who is considered as a promoter of a non-performing asset in accordance with the guidelines. So it's just been simplified, and I think they've introduced the concept of 1 year has now been linked to from the date of classification till the date of commencement of the CIR process, which was not there in the previous language.
Okay, Mr. Shroff, just to go back to the first point that we were making, this, in the ordinance, the language unwittingly seemed to include the illustrations that I was just offering my colleagues. For instance, we had raised the question that if at any point in time JSPL had become an NPA and at one point there was that cloud over it, then, by the connection of relationship, sort of Sajjan Jindal's company some could have interpreted, and I'm doing this very loosely, could have interpreted to be impacted by the ineligibility criteria. Similarly, for ArcelorMittal, which was invested in a non-performing asset, had more than 20%, and therefore could have been interpreted to become ineligible. Do you think those defects now go away?
My feeling is that by virtue of the clarification that they have given in 29 capital AJ, it's quite clear that they link the connected person to two kinds of persons: either the promoter, persons in management or control of a resolution applicant, or alternatively a promoter, person in management or control of the corporate debtor during the implementation of the resolution plan. So in a sense, they have sort of narrowed the scope down, and they have also clarified that a bank, an ARC or an AIF registered with the SEBI are not covered by the explanation 3. So there is a greater clarity now, and I think that's good, because an AIF in any case does not have a holding company or a subsidiary or an associate company at times when it is registered as a trust. So I think they have made this fairly clear, and it's quite transparent now.
Can I ask for your comments on what happens to instances like the ArcelorMittal illustration? I know you prefer not to be client specific, but just imagine a company, a large steel company, for instance, that's invested in a much smaller steel company, not in a promoter capacity necessarily, but with, let's say, 20–25% stake or some sort of control. Does this bill now not make such large steel companies ineligible to be able to bid for other stressed assets?
No, I think the definition of the word promoter, the definition of management and the definition of control follow the definition of the Companies Act. And it is an inclusive definition as far as control goes. So a minority stake which may have been taken by, say, ArcelorMittal in Uttam Galva or any other company that they're interested in, as long as they are not in the management, nor are they controlling the policies of the company, they're just a mere financial investor in the sense they've shown their interest to participate in a higher manner, that would not qualify them as a promoter or as in management or control, because under section 92 of the Companies Act, an annual return has to be filed disclosing who is the promoter. So as long as in the companies in which ArcelorMittal has sort of entered, and which may be a sick company, which may be an insolvent company in the sense as a corporate debtor, if they have not modified their annual return under section 92, or if they have not described themselves as a promoter in any prospectus, or they don't control the composition of the board and the policies of the board in terms of majority, they would not classify as promoters for the purposes of 29E. So I personally believe that the structure of companies like ArcelorMittal who have participated in Uttam Galva or other cases would not bring them within the prohibition.
Okay. Did you believe that was the case with the ordinance as well and did not need to be cured with the bill, or did you believe that the ordinance left that open to interpretation and now the bill cures that confusion?
Yes, I do believe so.
Okay, so that it was open to interpretation earlier, but the bill cures that confusion. You made the point that in the definition of connected persons, ARCs and AIFs and scheduled banks are now exempt, if I may use the term loosely. What are the implications of that? Why do you think they would have done that?
See, in a situation where at least an asset reconstruction company whose task it is to really securitize assets and holds multiple series of assets for reconstruction, they would have become ineligible had they not made this qualification or exemption from the purpose of explanation 3. The same also applies to an AIF, because these funds are at times set up as private equity funds for the purpose of distressed assets. So if they had not made these clarifications, a lot of the private equity or AIFs or asset reconstructions companies would have been sort of captured. Now take the case of a scheduled bank. If they have resorted to an SDR and effectively have converted more than 50% to equity, they would have per se become promoters for the purpose of Companies Act, and that would have also then disqualified bankers from participating in resolution plans. So they have in a sense therefore made it abundantly clear that a scheduled bank, an ARC and an AIF will not fall within the concept of a holding company, subsidiary or an associate company or a related party as far as explanation 3 goes.
All right, Mr. Shroff, you made one more point, and that is that you noticed some language changes in the, in when defining the promoter of a non-performing asset and his ineligibility. You said that this would apply for a period of 1 year or more, has lapsed from the date of such classification and who has failed to make the payment of all overdue amounts. What change did you notice? Because to me it looks fairly similar, if I'm reading this correctly.
See, if you read the original ordinance, was capable of a different interpretation, because there the language was used that it's a period of 1 year or more has lapsed from the date of classification. But date of classification to the date of initiation of the CIR was not part of the previous ordinance, which is what they have clarified now in 29AC. And they have also said that the promoter has the ability to make payment all the overdue amounts before the submission of the resolution plan, which was also the case even in the ordinance. So it's just a clarificatory change as I look at it, making it clear that 1 year is from the commencement of the classification and continues till the date of the CIR. So 1 year is now quantified in terms of start date and end date, which was not the case in the ordinance.
Okay, and this explicit, the bill seems to provide an explicit 30-day period for the ineligible promoter or ineligible corporate debtor to be able to pay the overdue and become eligible. That did not seem to be the case, if I remember correctly, in the ordinance. Do you think this gives a window of opportunity for promoters, let's say, of companies like SR, etc., to be able to work something out with their lenders, pay the overdue amounts, and then be able to become eligible to participate in presenting a resolution plan?
See, no, I would read this a little differently, because the provisos are essentially dealing with those people who are not qualified resolution applicants but had filed for a resolution, and because of the introduction of the ordinance on 23rd of November became disqualified. So in those particular cases, what section 30 subclause 4 has provided is that where you don't have any eligible bidder, then you can ask for fresh applications so that you can have an applicant who can take the company. And it further says that that period that you will have is not more than 30 days, and in any case you cannot exceed the overall time which is prescribed, that is 180 days or 270 days as the case may be. So this is in some sense just giving clarity as to how the committee of creditors can make a proposal or invite a proposal within a 30-day period extra, and then you can give the applicant a time period of 30 days to make the proposal without in any way disturbing the 270 days or 180 days timetable.
But how do you do
That's
that,
the way
sir?
I read it.
How do you do that, Mr. Shroff? If you give them an additional 30 days, just imagine a situation, and this did happen, you know,
Sorry,
for some
your
of
voice
this.
is breaking, Menaka.
Sorry, if you can hear me a little bit more clearly now. If you can imagine a situation where there was, you know, a resolution process that was underway, that plans had been submitted, and that one of the bidders.
Menaka, is that.
No, one of the bidders becomes ineligible. Now you have to scrap that earlier process, restart it, give that ineligible bidder 30 days to try and cure his ineligibility.
No, but the point is
how
that
do you
they
not
should have been
delay the
resolution
process?
applicants, as in they should have filed a resolution plan. If they were sort of thinking about it, then these two provisos don't apply. Because it is just to cover the situation where somebody who was previously eligible has become ineligible, thereby making the situation such that there is no plan, because the introduction was at a subsequent date on 23rd. So this is only to cover those situations where the act has, or the bill or the ordinance has made something which was eligible ineligible. In those circumstances, the law seems to be now proceeding on the footing that in such a case you can't consider a applicant as ineligible, or rather as eligible, just because they had made the proposal before 23rd of November. You will have to consider the applicant as ineligible, and the professional will then invite a fresh resolution where no other resolution plan is available. So if, for example, there are no plans surviving after the ineligibility, then he is allowed to ask for one more plan or invite people. And what it then says is that if you do that, you can allow that person to make his proposal within 30 days. So if supposing an applicant is a promoter, then he has the right to make that application within 30 days by relying upon that subsection C, and he can clear it within the 30-day period. So it's not instant. Once you ask for an application, a 30-day window is available for him to make a plan and get qualified. That's the way I read it.
So if I've understood this correctly,
the overall criteria being is that you will not
all I was trying to say is that you don't believe that that additional 30 days will delay in any ways the 180-day deadline or the 250-day deadline, with exception that's been laid down in the IBC. You're saying that the process will continue, the resolution applicant will submit his resolution plan and simultaneously or contemporaneously have 30 days to be able to pay the overdues and become eligible. That's how you're reading this, correct?
Correct. Yes, because the last proviso to section 30 clearly says that by this process of extension, you will not go over the period which is specified. So which means 180 days or 270 days cannot be exceeded.
Okay, just one quick question pertaining to the same point, and that is that if resolution plans were invited, only one had come in, that resolution applicant now stands ineligible on account of the ordinance and now the bill whenever it is passed. And then to that effect, if that resolution applicant is not able to cure that ineligibility or to rectify it, then the company moves towards liquidation. I understand this correctly?
Yes. So what the difference is this, Menaka. The first clause essentially says, the first proviso essentially says that for any reasons of ineligibility, if you have no valid plan or no eligible plan or applicant before you, you can ask for a fresh plan. The second proviso says that if out of those ineligibility set of 8 reasons, the reason is that of a promoter who holds a non-performing asset for 1 year, then that non-performing, that NPA kind of person or the promoter can make an application provided he clears off his total interest and loans within a period of 30 days.
Okay, all right. I get that.
That's what it says.
Okay, couple of more questions very quickly. There was confusion
so
about
one applies to all, the other applies is limited to C, 29AC.
Got it. There was some confusion when the ordinance was promulgated about the issue of guarantors not being eligible. Do you think that has been rectified in any way? Because there was a lot of commentary on how that sort of cast the net too wide. But to me, the language seems the same. I don't think it seems to have changed dramatically. How are you reading it?
Yeah, in some sense they have sort of made this explicitly clear, so nobody can imply any reason or state that this is an unreasonable period, or that you're asking us to pay immediately. All those kind of defenses which would have otherwise arisen or somebody may have challenged, that is taken away by virtue of the proviso.
No, sir, I'm not only talking about the proviso. I'm talking about the other ineligibility criteria, especially H, which pertains to those who have executed an enforceable guarantee in favor of a creditor in respect of a corporate debtor, against which an application for insolvency resolution has been made. That language seems the same. There was a lot of grumbling about that when the ordinance was promulgated. They haven't changed that. Do you think that might continue to pose a difficulty?
Yeah. See, the reasoning, there has been now a judgment of the Calcutta High Court explaining this particular clause. And essentially what it says is that this relates only to an invoked guarantee. So somebody who has given an enforceable guarantee and which guarantee has been invoked, then such a person is ineligible to make a bid because he is already out of pocket for that amount which has been invoked. So what they're saying is, if somebody has been made to pay under a guarantee, then such person who's made to pay under a guarantee by an enforcement action is not eligible under 29A. That's the interpretation the Calcutta NCLT has given.
All right. Besides this, did you notice there were any changes at all? Because this seems to be the sum and substance of the difference between the bill and the ordinance. And the follow-up question to that, of course, is, are there any changes missing here that you would have liked to see because of some of the confusion that the ordinance had created, but which have not come to light, in this bill?
I think, Menaka, that there are two reasons why additional stuff has not come. One is there's a committee which is constituted under the Secretary Ministry of Corporate Affairs, which is looking at major changes in the insolvency law, additional changes. And the second is that since this is an ordinance, the ordinance has to be tabled in a manner that it converts to a bill. So they may have a limited play in the joints effectively by saying that we'll deal with the ordinance as was, we'll deal with the bill in the context of the ordinance and not really introduce new stuff. If, for example, they were introducing new stuff, then I would have certainly liked to see how MSMEs or micro industries are dealt with in a different manner without clause C applying. Because in a micro industries, you don't really expect third parties to come in, and it will be invariably the promoter himself who will probably come up with the resolution plan. So this has been a discussion, and I think even the IBBI has come forth and said that we'll look at a different treatment in relation to MSMEs. But as I mentioned, because the ordinance and the bill is a replication except in relation to stuff which has been clarified, that may be the reason why this is not there. But there would be many other changes which I expect will come once the committee has completed its deliberations.
But Mr. Shroff, explain to me how any resolution process is supposed to continue and be successful if there are continuous changes taking place in the law that may deem some to be ineligible, some to be eligible, some further provisions within the eligibility criteria. If we are constantly work in progress, how does that give confidence to either the resolution professional to be able to conduct this in a sort of time-bound manner, or the NCLT to be able to rule on it to ensure that timelines are met, or even promoters to know whether they are eligible or not eligible?
See, I agree with you, Menaka. The problem will not be so much for those companies which are hovering around the 180-day mark, because they will apply for an extension. But those people who actually hit the 270, this problem will be a serious problem because they cannot apply at all. They would go into insolvency. So there is that unenviable situation which is arising out of the ordinance and the bill. But really it applies to those people who are within the time frame of 180 to 270. It cannot apply to a situation where 270 days have almost gone, because you don't have the 30-day window in most of the cases, nor do you have a 30-day window to make the payment. Effectively, it would mean a 60-day period still being available. So this will only apply to those cases where 180 days is about to get over or has got over, and an extension will be granted of another 90 days.
I can't recall if anyone's already hit the I can't recall if any of the large accounts have hit the 270-day deadline. Do you know from within your client pool whether people are fearful that they're very close to the 270-day deadline and the complications introduced by the ordinance or the bill, will actually prompt them to move towards liquidation because they don't have much clarity?
No, on the big 12 which were brought in by the Reserve Bank of India's ordinance and the changes made, they are almost all near the 180 day. So they have not gone into the 270 day framework. They will have this ability. So you would see situations where the big 12 have got the flexibility of using this extended term. But the smaller ones which had been filed between December and May of this year, they may suffer because their terms may be already over.
And you expect that the NCLT will be generous in granting these extensions given the legislative complication that's been created?
Yeah, I think because of the uncertainty which has been brought by the law, if somebody is at the cusp of 180 days, I do expect the NCLT to be liberal in granting another 90 days extension.
Okay, I have one final procedural question, Mr. Shroff, and that is that this bill has to pass before Parliament finishes this session, or else the ordinance has to be re-promulgated, correct?
Yes. So the bill will convert into an act once it passes through the lower house and the upper house, then it will convert to an act.
All right, Mr. Shroff, appreciate you finding the time to speed read this for us and give us insights into what and how the bill is different from the ordinance. Thank you very much. I'm sure we'll come back to you with many more questions as we've had time to read this in more detail as well. Shardul Shroff there laying out for you the critical differences between what the bill that seeks to amend the IBC spells out in terms of eligibility and ineligibility criteria and how that is slightly different from the ordinance. Thanks very much for tuning in to Bloomberg Quint.